And I'm not going to hear any, I have a baby and tears and all of that. Not going to listen to it. Do you understand? So what I'm going to do in cause number 19-33340, I'm going to find sufficient evidence to revoke your revoke your probation, but I'm not going to do that. I'm going to continue your probation. I'm going to extend that probation for 5 years. And Ms. Leonard's here in 3 cases. One is cause number 25 DCCR 0297. That is the new theft of property case, a state jail felony she entered plea of guilty to. And then we have 2 MTRPs, one in cause number 19-33340, theft of property, and 20-36095, a theft of service. And in each of those cases, is she on a deferred in both of those? Or is this true? I'm trying to, sorry, I should have. Is it a deferred probation?
Let's see, Judge.
No, they're straight probation, Judge.
Okay.
Yes.
So they were deferred, and then we were here, and then revoked that deferred and reassessed and did the 2/5 at some point. Is that correct?
The last information I have in my files is she was on a straight post-conviction probation. I don't know if she initially was on deferred or not.
Yeah.
I don't
Okay.
know.
All right. Yeah. Okay. So the biggest issue, one of the bigger issues that I had when we were here for sentencing, based just on paper and the appearance of this, I don't disagree with Mr. Coleman's assessment of the case with the criminal history of Ms. Leonard with these types of offenses, and which the criminal history is these 3 cases. There aren't any other cases. And the new offense date was August of 23. And it's kind of just unknown. It sounds like why that case was delayed in prosecution. Doesn't look like anybody knows. And so the time frame between that and now, and the lack of any other cases while Ms. Leonard has been out and on probation during that time and doing well, it looks like otherwise on probation, is what leads me to potentially move forward with continuing the probation potentially on the others and giving her a probation on this one. So there was no agreement on any of these, but it looks like there was an issue with regard to the amount of restitution. So let's go forward with that. Have you guys come to any type of agreement on the restitution?
We are very far
We're very far apart, Judge. And I guess one of the issues that we have is I believe Mr. Coleman's got some exhibits that are going to go back to 2022. I would object to looking at anything outside the range in the indictment. The indictment goes from August 23, and we'll get to the exact dates.
Let me get it pulled up as well.
August 24th, 23 to September 4th, 23.
Okay,
I would ask that we remain in that range.
I would think legally that would be probably what I would need to do.
Judge, it's a continuing course of conduct. The theft is. I'll be honest, Mr. Ross just brought that to my attention this morning. I haven't had a chance to research it, but he certainly has had all of the restitution information showing that it's going back to 2022 in that discussion. So it's not an unfair surprise for him to know that we're looking for restitution going back.
Well, but I think the allegations, and obviously I understand the honor about as well as any of you guys, but those are some pretty specific. I mean, that's a very short time frame that is alleged in the indictment. Talking what, 4 days?
Well,
5 days?
yes.
Well, yeah.
From August 24th, 2023 to September 4th.
I'm sorry, I'm looking at an old indictment. I'm sorry, hold on. I was looking at another case.
About 10 days, maybe.
Hold on. So in the new calls number. So yeah, this one is August 24th of 2023 through September 4th of 2023. So less than a couple of weeks or so is the allegation. And I don't want to have to keep coming back here. But I think to go back, if it was a few weeks off or a month or two off, but if we're talking years of requesting that, then I think that's something that indictment needs to allege. And so we can go forward with that time frame today. I think legally that's where we need to be. She's already pled to it, so I think it's kind of late to amend the indictment. So with regard to the time frame of August 24th through September 4th of 2023, what is the amount between that time frame? Do you guys have that? Or need some time to look at it again to make? And I mean, and the unfortunate, I want to make sure you guys know how I am. If someone has had something stolen, I want them made whole as much as possible. I just don't think we can go back
Sure, Judge.
that far legally. So I want to make sure that the victim understands that as well, that we've got kind of a limited time frame here that we need to move forward on if I'm going to order restitution and probation. Y'all need a minute to do some math?
Just a quick minute. Just
Yeah, y'all go ahead. Y'all have a seat based on, I guess, that. See if there's something you guys agree to as far as that time.
just based on an on or about date, and they understand that the court's willing to kind of go back a number of weeks. I've got receipts to go back as far as, I believe, August the 9th of 2023. I don't know that that would necessarily be, I think that would be enveloped in the on or about. I mean,
I wouldn't disagree with that.
so
So August 9th, 2023. And then what was the last?
the last
Is
one
that the
was-
September 4th date?
the last one is, I don't want to misquote. Let's see here. September the 4th is the last day.
All right, so you guys figure out what between August 9th and September 4th of 2023 number is and see if there's an agreement on that number. If for some reason there's not, then I can take a look at the receipts that you guys have and then we'll go forward. I'll hold it for a few minutes. Okay, we're back on the record. Cause numbers 25 DCCR 0297, 19 33340, and 20 36095. Y'all have an opportunity to kind of go back through the receipts as far as that time frame legally that we can kind of talk about on this case.
We have judged. With
Mr. Coleman came up with a number of $2,407. In speaking with Ms. Leonard, her recollection actually is a little bit more than that. She thinks somewhere between $3,000 and $4,000. We had agreed to, or we had offered $3,500, and I think that Ms. Leonard feels comfortable paying back as far as restitution.
So if she agrees that it's between $3,500 and $4,000,
Between
then
$3,000 and $4,000.
3 and 4, I'm more inclined to go on the higher end of that, just based on the nature of the time frame that we're unable legally to look back on. And so I would be inclined to order the 4,000, Mr. Coleman.
Judge, that makes perfect sense. I've spoken with the complainant who is here today, the district manager for Sutherland's. His position is he'd like to be heard by the court. He was thinking that if the defendant was placed on probation, that they'd be getting a lot more in the way of restitution. I explained to him how we arrived at where we are, but he still wants to address the court and quite possibly ask the court to reconsider. If he's not going to get more than what he's getting in the way of restitution, he would want the court to reconsider some type of form of jail time.
Okay, and sir, you can come on up. Miss Leonard, if you'll just kind of slide around.
For the record, the witness's name is David Powell.
All right, thank you. Good morning, Mr. Powell. Thank you for being patient with us this morning. It was a big morning here. Mr. Powell, would you please raise your right hand?
Yes.
Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you, sir.
Mhm.
And Mr. Powell, you kind of heard where we are on this legally. I understand there's a significant amount of restitution that you believe could potentially be owed based on some prior dealings that aren't within the time frame that we're talking about. Is that correct?
That's correct.
And I'm going to just, if it's okay with everybody, just let Mr. Powell tell me what he needs to. If there's any questions of him after that, I'll gladly let you guys ask questions, but Mr. Powell, you can go ahead if you would like.
I don't have any questions. Tommy explained to me what the restitution would be. We lost a substantial amount of money.
Sure.
And if that's what we're going to be awarded, I would prefer jail time versus the restitution.
Okay, I understand that completely. Anything else that you'd like to say? Thank you. Go ahead, Mr. Coleman.
Just really briefly, Mr. Powell, was any of these losses covered by insurance?
No.
What, if any, effect did it have on Sutherland and its practices going forward?
Other than the loss of funds, quite a few effects. We had to change the way our IT department had to change the way some of our transactions are rang, and that they can be rang and returned and voided. Myself, I'm a district manager, so I manage several stores. So it added quite a bit to my duties as far as verifying reports, verifying voids, verifying where transactions are run, and looking at each store transactions daily and talk to the managers to verify why this transaction was run in a certain way and why it was voided. So it adds quite a bit more to my morning. Before I can get started on my store, which is Beaumont, I have to verify the other stores, and I have to go through and do a lot of extra work.
And Mr. Powell, we are cutting this down a lot more than what you and I kind of rehearsed or scripted. Just high level, 30,000 foot level for the judge. We have documents here that will show that this defendant essentially engaged in a scheme of enlisting other people or asking other people, but unbeknownst to them, to void transactions and later on remove money from the register. Am I dumbing it down too much?
No, that's actually correct.
Okay.
That's pretty much how we found it, because it was a set pattern. The way the system works is if you void a transaction, the transaction disappears. So if you void a transaction and take the money out, we don't know because the money's gone because the transaction's gone. What was happening was a transaction will be rang, the customer pays cash. I reprint the receipt so I know how much to ask for a void for. They would void the transaction, and now I know how much money to take out of the drawer. So what I get in the morning in the past, on my reports, it just says there was a void on, done this day for this amount of money. It doesn't say why or how much or who. Now, and of course, with me trusting my cashiers and my office crew, we have a void, and it says that the customer paid with a card and not cash. I assume that that's what happened, and I let it go.
We've got 139 pages of documents, and these documents essentially show 68 voided transactions totaling $31,134.86, going back to July of 2022, correct?
Correct.
State offer states too, Judge.
I would object to any portion outside the date range in the indictment, Judge, but other than that, I don't have any objection to it.
I mean, it's been testified to. I don't think I need those, as I'm going to take it into consideration to the extent that I think appropriate. Obviously, the amount have limited, but the fact that there was potentially more that for some reason wasn't in that indictment, I will take notice of that.
As the witness, Judge.
Thank you. Any questions?
No questions for Mr. Powell, Judge. I know he's been here at every court date. I want to first apologize to him for having to come here and thank him for being here as well.
Thank you very much, Mr. Powell. You can have a seat. I mentioned earlier, and I think I mentioned it really erroneously, that Miss Leonard had been doing well other than the offenses on probation. It looks like there was issues with community service and lack of doing community service. It looks at only 1 hour of community service had been done. As of March 13th of 2024, 20 hours, October 30th of 2025, after being on probation all this time. So it looks like there was some issue with that. Financial compliance, it says, has been poor. restitution obligations remain unaddressed. And so she still hasn't paid back the restitution that was owed in the first case to Specs and the second case to Cons. Is that correct?
Has she made up any community service hours since
She's
she
done,
quit?
she's done just 31 overall.
31.
31 hours, yes, ma'am.
All right. Well, I'm not real sure that I'm on the same page that I was before, so I'm going to go ahead and allow new argument based on Mr. Powell's testimony as well as just kind of where we are now. Mr. Rojas?
Yeah, Judge, we asked the court to keep her on probation on the two previous cases and grant probation in this new case. As the court's already said, there was a delay in filing the new case. She has not been a perfect probationer, but certainly doesn't appear that she's had any new offenses. In the meantime, she's had a newborn baby. I believe that was one of the reasons the court let her out on bond when we had the bond hearing. Since we've been to court and since these new cases have been filed, it appears that she's been staying out of trouble. She's at least able to do that. And as to the not being able to pay the restitution, Judge, I think she's wearing her uniform today. She's working at McDonald's, not making a whole lot of money. So restitution is going to be tough for her, no matter how much it is. So we ask the court to consider all that and go along with the court's previous leanings and keeping her on probation and giving her this new opportunity on the new probation case.
Okay. Mr.
I'll be brief, Judge. I think the facts speak for themselves. Judge, I'll just direct the court's attention to page 3 of the PSI, the very first paragraph, where the defendant said, I let a customer walk out of the store with unpaid merchandise and he paid me instead. Judge, that's I don't have the words for how that's so understates the 68 voided transactions over over the course of a year or so, Judge, to the tune of $31,000. A theft from Specs, a theft from Cons, and now a theft from Sutherland's. She's a serial employee theft offender, Judge. And I get the court's tendency and leaning to give people second chances and try to recover restitution, but the state's position is, but it always has been, is that this case merits some form of jail time.
Just a second, look at one more thing here. And Ms. Corr's here today as well. And Ms. Corr, do you have anything to add?
Judge, just that I got her case back in May, and she was transferred to the high needs case though because she thought she was getting evicted, and that's why I have her on my caseload now. But it's been sort of slow progress with her. Her just doing the community service hours just October since 2021. She's been on probation. And she has been making some good faith payments, but she hasn't really addressed the restitution yet.
Have the payments been redirected towards restitution first, or are they still going towards the probation fees?
They're still going towards the probation fees.
Do you have anything to say, Ms. Leonard?
Yes, ma'am. Lot to say. I know we probably don't have that much time, but I'm sorry. I take full accountability for my actions. I wasn't the best person. I didn't really care about things I didn't have. I felt like I didn't have anything to live for. I didn't have nobody, I woke up every day and just went with my day. But I'm a mother now after 3 miscarriages and being told that I'd never be able to. I take care of my child by myself. Her dad's not in her life. The only help I have with her is my mom. And my mom's a single mother of 4 herself. So, like if I'm not at work, my daughter's with me. I do everything by myself. Doctor's visits, cardiologist visits because she has heart murmur, dentist visits. I do everything by myself. I'm not that person anymore. I never believed that I had a reason, but I have. the purpose now from what I, believe.
I mean, you don't deserve another chance. I appreciate, obviously the change in your life and how that can be very substantial. But I don't understand. And I don't think Mr. Coleman was a part of, obviously, why there was a delay. That still gives me some pause in the case, is for whatever reason, this sat somewhere in intake or at the agency. We're not sure which, why this case was delayed. And really, basically, for that reason, and the fact that there has not been any new allegation since October of 2020. Well, this allegation was from August of 2023. And here we are in March of 2026. And there hasn't been any new allegation. And I just don't understand the length of time. And Mr. Powell, completely understand your position. There's some other things, obviously, too, that I'm taking into consideration. But Ms. Leonard, if I give you an opportunity today, I don't know how many jobs you've got to get, but you're going to pay some restitution or you're going to go to prison.
Yes,
Period. That's it.
yes,
I don't anticipate probably that you can pay it all in all of these cases, but you're going to pay some restitution.
Yes.
You're going to be on probation for a very long time to be able to do that, because I can extend your probations for a very long time. And so if you really have changed your life and want to be there for your daughter, you're going to be given that opportunity, but you're going to do different. Or else you will be back in here and I'm not going to hear any, I have a baby and tears and all of that.
yes,
I'm not going to listen to it. Do you understand?
yes,
So what I'm going to do in cause number 19-33340, I'm going to find sufficient evidence to revoke your revoke your probation, but I'm not going to do that. I'm going to continue your probation. I'm going to extend that probation for 5 years. And then I will go through some specific requirements on all of the cases in a minute. And then in cause number 20-36095, also find sufficient evidence to revoke your probation, but I'm not going to do that. I'm going to continue you on probation, going to extend that probation for 5 years. Order, obviously, that you follow all of the rules and conditions of probation, including completing your community service and paying more towards restitution. I'm going to find in cause number 25 DCCR 0297 sufficient evidence to find you guilty. And at this time, I'm going to find you guilty, sentence you to 2 years into the state jail prison, but probate that for 5 years. So I could only probate it for 5 years at the beginning. So you're on probation for 5 years. There won't be a fine in that case. There will be restitution owed in the amount of $4,000. I would like for all of Ms. Leonard's payments to go towards restitution. At this time, it can be divided amongst them, however you guys feel appropriate. But at this point, we need that money going back to the victims.
Yes.
And so let's do it that way. And then Ms. Leonard, you're going to remain on the high medium caseload. And also you're going to be under zero tolerance.
Yes,
Okay. So there's no more whatever. It doesn't matter. It doesn't matter if you miss an appointment. Obviously, if you commit a new offense, test positive, you don't pay restitution, if whatever it is, doesn't matter to me. One thing means you're back in here and you're looking at those 3 2-year sentences, and they can be stacked because this one was convicted after those other 2. So I think we probably can only stack 2, and which means you could end up with a 4-year sentence instead of a 2-year sentence. And I can assure you that Mr. Coleman will remind me of today. He will remind me of Mr. Powell. I typically don't forget things like this. I don't remember a lot, but when we've gone through this as much as we have, it's never a good thing when I remember you or your name, and I do now. So you don't want to be back here in front of me because you now have 2-year sentences. There's no negotiation on whether or not you get less than that. If you violate, it's 2 years in the state jail on every single case because that's your sentence. And then the only determination that would be made at that time is if I stack it or not. Does that make sense?
Yes.
All right. These were not agreements. So there are some limited rights to appeal. You can talk to Mr. Rojas about that. I'm handing you the trial court certification. Also handing you a certification regarding your ineligibility to possess a firearm or ammunition. I went over that before, I'm sure, but you were ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Rojas. Probation, you need to stop and talk to her. She's going to go over all of that paperwork with you. Thank you, Ms. Core. Thank you, Mr. Coleman and Mr. Rojas. And thank you, Mr. Powell. Yeah.
And what's the status of that new county case in Waller County?
Hayden Dickinson?
I've got an offense date of August 12th of 25, an assault, same type case as this one.
From out there, and then she went out there.
Oh, so you didn't get a new case there?
You were arrested out of county on this one.
That's when I was on college campus.
Okay, so they just made it look like it was another, okay. Before I go forward with your sentencing, Mr. Hayward, I want to have you tested this morning to make sure there's nothing in your system. Have a seat in the jury box. Let's see, you've got a sentencing on Lauren Bridges. Mr. Parker.
That's not good. She's here.
All right, ma'am, are you Lauren Bridges? And Ms. Bridges was previously in court, entered a plea of guilty to credit or debit card abuse. I received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections?
Another more, Judge.
Just ask the court where the restitution is.
Just for the court record, she's still in treatment, Judge.
The restitution in the amount of what?
It looks to be between 600 and 800, so I'd say we go on the low end.
Okay,
In all fairness.
yeah. Any issue with that?
No, Judge.
So I want to know more about treatment because it looks like there's pretty serious issue, and what I had written down here was inpatient treatment, but
She went to treatment, was in treatment
right.
before the warrant came out. And then once the warrant came out, she turned herself in. And then once she bonded out, she went back to treatment. Well, you can tell her what you're doing now.
Yes.
It was inpatient, it was in-house treatment, right?
At Riverwalk Ranch.
Yes, still there.
So you're inpatient there.
Yes, ma'am.
And how long is that program?
It can be up to 6 months. I do have a recommendation if it's okay if I go from there onto sober living if they're agree with.
Mm-hmm.
On the 10th, I'm supposed to be graduating their program and going into sober living in Tarrant County, which is Fort Worth.
I have several letters from them. This was prior. I don't know if they're really applicable to this, but.
So February 10th is graduation day? And, okay. And do you have any information specifically about the sober living place? Do you know what it'll be? Do you already know information about where the sober living is going to be, or will they tell you when it gets closer?
It's gonna be in Tarrant County, which is in Fort Worth, Texas. I don't know I'm not gonna know the exact address until the 10th. I could possibly get back there today and see if we can get an address today.
Okay, all right.
I can send it in.
Okay. You'll need to obviously get that for probation because the first step of once you're on probation is going to be to get your case transferred to Tarrant County.
Yes, ma'am.
And then whatever the requirements or conditions that I set, you'll be able to do there in Tarrant County.
Yes.
So any other issues, Ms. Smolfino?
It says in this letter, Judge, when a client successfully complies with the detox vegetable program, they're offered, encouraged to continue treatment through our partial day program and evening intensive outpatient program in Fort Worth at the Fort Worth Recovery Campus.
Okay.
That's
And you
just the one
intend
that-
on living it sober living and doing that as well? Whatever the outpatient is that they recommend?
Yeah, that's what it is. It's PHP and IOP. So you go through the PHP first, which is like you do their housing, their sober living housing, and
Right.
you go to the classes during the day, during the week, and you work also. And then the IOP will be once you
Intensive
go
outpatient
to
part.
different care.
Okay.
Level of care.
Okay, sounds good. All right, so it sounds like you're on the right path,
Yes, ma'am.
Ms. Bridges. So I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney. Find you guilty of the state jail felony offense of credit or debit card abuse. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison, but I'm going to probate that for 5 years. You're ordered to pay the $500 fine, also ordered to pay $600 in restitution, excuse me, and to follow all of the rules and conditions of probation. That is going to include continuing and graduating from the Riverwalk inpatient program that you're in now. Also following through with whatever their recommendation is for outpatient care, the sober living. I'm going to grant, I'm going to allow you to do all that, but I'm not going to just allow you to do it. I'm going to require it. Okay, so you can't leave there until or unless they say that you have gone to the next step or you are an outpatient, you can live on your own and all of that. Part of your order now and part of your probation is going to be to follow all of those recommendations. Okay. If you do everything you're supposed to, this is a great opportunity because for all practical purposes, your case here in court is over and you'll be able to serve that 2-year sentence while you're out on probation. The other side of that though, is if you violate any condition of probation, you relapse, if you end up committing a new offense, whatever it is, then you're going to be back here in court and you're going to be facing that 2-year sentence that you just agreed to. Do you understand? Also, it's important that you know when your probation gets transferred to another county, it's still here. I still am in charge of your probation. So you kind of have double duty. You'll be able to go in person, obviously, and do everything you're supposed to there in person in Tarrant County, but you are going to be required to either by mail or online, check in here and report. So you've got to report in person and online or by mail here. If you don't do one or the other, that you have to do both of them. So don't forget that a lot of people will just kind of forget about Jefferson County, but this is where it all stems from and you could end up back here in prison, okay? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Parker. All right, if you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. Allison Strom, Mr. Parker, to sentencing. Strom. Thank you. Good morning. Are you Allison Strom? And Ms. Strom, are you sick today? I'm sorry.
She has COVID.
Oh, step outside the courtroom, please. Why would you come forward with COVID? We'll reset her. Tell her she's reset for a couple of weeks. Let's see. Adrian Howard, Mr. Parker, come on up, Adrian Howard. All right. All right, Mr. Howard, you tested negative, which is obviously good. Let's see. All right, and so Mr. Howard was previously in court, entered a plea of guilty to the third-degree felony offense of assault family violence by impeding breath or circulation. I have received the pre-sentence report and reviewed it. Has everyone had an opportunity to review that pre-sentence report?
We have, Your Honor.
Yes, Your Honor, we have.
Any additions or corrections?
Not by the state judge.
All right, Mr. Hayward, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Obviously, that is going to include that you cannot have any contact at all with Brianna McClain. Are y'all still in any type of relationship? Okay. So if you're somewhere and she shows up after you, you're the one that has to leave. No contact, no communication, no sending messages, anything like that, okay? If you do everything you're supposed to, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, if you're successful, the case will actually be dismissed. You'll never be a convicted felon. The other side of that is if you violate any condition of probation, you could be brought back into court, you could be found guilty, and you could be sentenced anywhere in the range of punishment, which is up to 10 years in prison. Do you understand? Also, it's important that you understand, I know you've talked about some interest in going to the military and you've got some college under your belt and things like that. If you do everything you're supposed to and get that community service done, do any classes you're required to do early on in your probation, I sign early terminations from probation all the time. But it's going to be up to you whether or not that happens because you're going to have to do everything properly from the very beginning. Okay. All right. I'm handing you the trial court certification that shows that this was an agreement that I followed. So you waived your right to appeal. You also just need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. All right. Good luck to you, sir.
Thank you.
See, is there a Mr. Stringfellow? Good morning, sir. Are you ready to announce on John Roy? Oh, okay. I'll hold that. Thank you, Mr. Parker. Did I just sentence? You want to send it to me or just? Oh. That's Alan's. Alan, can you get Miss Bridges back up here on one of the paperwork that came through last time? Her signature is either missing or didn't get on. If you'll come bring her, make sure y'all get that signed. Let's see. Mr. Rennick and Mr. Smith on Mary Lockard Fury. Good morning. Good morning. You're Mary Lockard Fury, and where are we?
I don't know, Judge. I was out last week on vacation, so I didn't get a chance to check with the U.S. Attorney's office. I think last time I was here, you gave you
I did. I talked to him. I did. I talked to Ray, and he told me they were trying.
Followed up as well. Yes. I don't know what the delay is. I have been told that there are charges coming. The dilemma is I showed you the emails I had.
So the information that I received was that they have not received documentation from all of the agencies that are potentially involved. And so from complaining witnesses from different areas, I guess, in different agencies. And so they were working on getting that. What he told me he would do, and hopefully he has, is reach out to the complaining witnesses in our cases so that they will know that this is not something that what's going on, that we're not delaying this just
I have
because
given him
that their
their
cases are being
names.
given attention, but being given attention in the federal system. So I'm hoping that he reached out to them.
I have explained to the victims in these cases what's happening with these. I have told them what's coming, and I have given him their personal contact information
Okay.
quite a while back.
Yeah.
I know he's doing more than just Jefferson
I
County.
think he's got what he needs from us and our agencies. It's some other counties. And so I might shoot him an email again and follow up because we reset this budget.
I mean, Judge, it was, to be honest, if the feds were involved, this program was lost.
Yeah. So I will, all right, let's do 45 days. And I'll shoot him another email just to kind of see where they are and get an update from him. Maybe if we all keep hitting them, they'll
I'll try
do
and get
something.
him to. Again, I was here last week.
That's all right.
I
Okay.
didn't have a
Thank you.
copy.
Stay in touch with Mr. Rennick. He'll let you know when you need to be back.
Thank you, sir.
Thank you, sir. And then you've got John Sharp,
Yes,
Mr.
Judge.
Rennick.
There's a video that I sent her last week. There's a civil case that's pending as well. And I think that you discussed an offer, but I think she wants the video from you before finalizing.
If you would allow, Judge, we had a good conversation last week. I just couldn't open the video link he sent, so we can try to provide it a different fashion. I feel like that'll result.
Okay. We'll just do a normal reset to give you some time to take care of that. Make sure you stay in touch with Mr. Rennick, Mr. Sharp. He'll let you know when you need to be back. Okay. You're free to go. Thank you.
Judge, the last one I have is just get over to the paperwork right now.
Okay. I'll hold it for Flea. Thanks. See, Mr. Reynolds, you have Deshandra Joseph. Do what? For what? She's calling her name. Good morning, ma'am. You're Deshandra Joseph. And Ms. Joseph's case is set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, I talked to the prosecutor. There may be a resolution to the matter. I think she wanted a couple of
Judge,
days.
this is a case I picked up off another docket, Mr. Hoffman last week. I was able to speak with the complainant. I was not able to speak with her daughter. If you would allow me the opportunity, maybe return that phone call today.
Sure.
And see, and I know you would like a pretrial announcement, but maybe a couple days. to
No, I
figure it
understand.
out.
I
Otherwise,
understand.
I can be ready very quickly.
So I guess what I'd like to do, if possible, is see what you guys can figure out by midday tomorrow, just so I have an idea to try to number the cases for next week. And if it is going to be something that gets worked out, I can always take care of that on Monday instead of this week if necessary. But just let me know where you
Yeah,
get.
there's a misdemeanor that is a companion to this case, and I think anger management may have been taken. So we just kind of need to figure out where we are
Okay.
exactly, but then, if need be, the trial should only be 2 or 3 days.
Okay, I'll just kind of hold it for you guys to get with me. Just call me or email or text in a group or whatever, okay? All right, stay in touch with Mr. Reynolds so that once he hears back from Ms. Malfino, make sure you're available to him to visit this afternoon, tomorrow, so that I'll know if your case is going to go to trial next week or not. Okay? All right, thank you. Oh, wow. Look at that. I was just about to look for that. It's crazy how I always want these new things every week.
I know.
You are. You have every,
That's my excuse today.
use it. Use it while you can. Oh, this is next week, because you've got Master Word
Yes, ma'am.
for next week. Okay.
For process.
Yeah. That's gonna be the, let's see. Mr. Doyle on Maverick Neal.
Autumn Payne, Autumn Payne.
Good morning.
Morning, Judge.
Nice to see you back.
Thanks. Trying to get in better shape.
Good.
He's a little nervous, Judge.
Okay. We'll get through it. Good morning. You're Maverick Neal. And Mr. Doyle, will your client waive the formal reading of the indictment?
Yes, ma'am, he's going.
Mr. Neal, in cause number 24, DCCR 2436, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon. That's from October 26th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
Nobody made you plead guilty, right? Okay. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Did you go over these documents with Mr. Doyle?
Yes, I do.
Do you fully understand them? Do you understand those documents that you signed?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be giving up or waiving any right to appeal? So you can't change your mind later if I follow this agreement. Do you understand?
Yes.
And it looks like the agreement that you've reached is for, is that a 5
Yes, ma'am, what's up?
5 years deferred probation? There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding of your punishment? So if I follow the agreement, you would be on probation for 5 years.
Yes.
Okay. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Are you a U.S. citizen?
No.
Are you a
Yes.
U.S. citizen? Okay. State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Neal is not competent?
Not that he's not, that he's competent.
Okay.
Not in my opinion.
Thank you. And so, Mr. Neal, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. When you leave today, you need to stop and talk to probation on your way out, and she's sitting at that desk right over there. All right? So stop and talk to her, and then we'll see you back at sentencing. Do you understand? Okay, so you'll have one more court date for sentencing, okay? Okay, stop and talk to right over there, the lady. Thank
Thanks,
you.
Judge.
Here's the date.
Thank you. See you, Pete.
Mr. Gertz, you've got John Jackson. Morning.
Morning. How are you?
Good. How about you?
Good.
Good morning, sir. You're John Jackson.
Yes, Your Honor.
And Mr. Jackson's case is set for trial to begin with jury selection next Monday. And what is the announcement?
We ready? State's ready, I believe, Judge. There's one witness that is unavailable, but I don't think it's absolutely an essential witness. I think our eyewitness and we do need our.
Okay. I'll number the case tomorrow after docket. If anything else comes up, just let me know. Is there any change in, looks like it was back in July, there was a rejection, any change in offers or anything like that?
Not that I'm aware of, Judge.
It was a 10-year deferred offer. Okay. Mr. Jackson, stay in touch with Mr. Gertz. He'll know tomorrow midday what the trial order is and when you need to be back next Monday. Okay. Yes, sir. You're free to go. And then you have Shay Morgan, Mr. Gertz.
Some problem. She's just on announcement. Judge, she was outside earlier.
Jay Morgan. Mr. Roy.
Yes, and Judge, may I have like a few minutes? Can I hold on her?
Yes.
If you don't mind.
Yes.
I was all ready on my other people, but I'm not ready on her. And then don't surprise me with the next person you say.
I know. About David Hatcher. Is he here in the courtroom?
Yeah, he is, Judge.
David Hatcher.
Judge, at your next break, may Ms. Malfino and I come and talk to you about something else.
Yeah, it'll probably be at the end of the docket.
It's fine.
Okay.
It doesn't matter. I'm patient.
Okay.
I got nowhere else to be.
Good morning. You are David Hatcher.
Yes, ma'am.
And Mr. Hatcher's case is set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, we were close to a resolution the other day, but we're not. We don't have an agreement in this case. However, I have been in contact with my victim and their family. They're still going through occupational therapy and psychiatric evaluations all related to this. And he's not in condition to appear for court for trial yet, Your Honor. So I have to ask for a reset. I think we'll be able to get him out here after a reset. They live outside the Metroplex. But more importantly, his medical condition doesn't really allow him right now to come out of court testify.
Any issue with the reset? One reset, Mr. Gertz?
No, not at all, Judge.
All right, so I will reset it one more time. Obviously, at that point, it'll be time to get it moving. So everybody be ready at that next one. But yeah, I'll give you some time on that.
We understand.
Stay in touch with Mr. Gertz. He'll let you know when you need to be back. All right, thank you. And then you're going to work on
This morning.
paperwork on Cracknell.
Oh, yeah. Well, yeah, Mr. Hoffmeyer's not here. That was one of the things I'm concerned about. Like, Mr. Hoffmeyer made me a whole new offer, as you know, but like we haven't run it through.
That's okay. I think Miss Malfino. Oh, shoot, that doesn't work. That's going to be frustrating. Hold on a second. Hold on.
Jason.
Mr. Gilthorpe? Ms. Hawkins? Mr. Kimler, you've got Kashawn Purdy, 2 cases. Good morning. Sorry, I missed you and I called Mr. Kimler. Give me just a second. I'll recall your case. Sorry. I looked up and looked right through you, apparently. You were in the corner. Yeah, definitely age before beauty on this one. Did you hear that? I don't think anybody would argue that one.
Purdy.
Kashawn Purdy. Good morning. Good, how are you? Yeah, glad to have you back. Good morning, you're Kashawn Purdy, and we've got 24 DCCR 1272. Ms. Purdy is on probation and has a motion to revoke that probation. And then 25 DCCR 1523, a new offense of injury to a child, elderly, or disabled individual. And what is the announcement?
Your Honor, she was going to plead untrue to the new case, and I'm sure Mr. Nichols will have an opportunity to prove that in the context of the NTLP.
That's correct.
Okay, no agreements.
No.
And I do want to make sure, have y'all, it seems like 9 times out of 10, we set these for special hearing dates, we get witnesses here, and then something's worked out. So if you guys are going to work something out, then I want y'all to work it out, because I keep doing these and we set them for a hearing. I don't remember the last time I actually had a hearing on an MTRP. We get here, the state's brought witnesses, and
It was Mr. Hoffbauer's case, so I'm not sure. I believe, wasn't it Hoffbauer's?
It was.
Yeah. So, I'll solicit.
why don't I hold it for a minute?
solicit
And let me hold it before we go through that motion. Y'all talk about it for just a minute. I just want to make sure. I mean, it's fine if you need a hearing, but I don't want to keep setting hearings just so that we see if witnesses really show up. And then we've got officers who have other things they could probably be doing that's more important. All right, have a seat, ma'am. Mr. Jubert,
Your Honor, she won't take the offer, so I'll just
I'm sorry.
she refused.
Okay, that's fine. I'll do the plea in just a minute. How old are you, Mr. Jubert? 18 was the last time you smoked dope. What? Last week? What made you think that was a good idea with 2 felonies pending to come be smoking marijuana? You don't know? And you're not working? Obviously, you know that's a violation, number 1, of the law and of your bond conditions, right? Speak up. How do you think you're going to get a job if you're smoking marijuana? What? You quit last week? Wow, congratulations. You realize how ridiculous that sounds to say I quit last week? Mr. Jubert, I'm going to find today that obviously that is a violation of your bond conditions in each of your cases. I'm going to raise the bond in each of your case because of that violation. Let me see what they were previously at. And cause number 25 DCCR 1130, I'm going to raise your bond to $15,000. And I'll go over conditions of both of the bonds in just a minute. And then in cause number 25 DCCR 1131, Going to raise your bond in that case also to $15,000. Condition, if you make the bonds in both of those cases, is that you have to have a drug patch on at all times. You have 24 hours from the time you make a bond to get a drug patch put on. A drug patch is something that goes on your arm. Your bondsman can tell you where to get them. You have to have them changed every 2 weeks. If they test positive, then obviously I'll know you're still using marijuana and you haven't actually quit. You're going to go right back into jail with much higher bonds. I would anticipate if you make these bonds quickly that the first patch might be positive, but the patches are going to show me an amount, not just a positive or a negative. So if that amount is not going down, then I'm going to assume also that you're still using. Do you understand? All right, go back with the bailiff. Is that for me? Okay. Mr. Gray, come up, please, sir. It's very important that you are on time because what happens is your bond gets forfeited. So I'm going to recall that bond forfeiture. Mr. Gray, did you have an opportunity to get someone hired?
Yeah, no, but I got your,
Who'd you talk to?
full list of them.
Just tell me who's on the list.
Corey Crenshaw, Lander Law Firm. Left a message with them, they called me back. It was $5,000, without trial, $10,000 total, $2,000 down. Frederick Law Firm, W.M. Marcus, I think it's Wilkerson. I did the other one's Eric Franklin, $10,000 and $6,000 down.
Are you working, Mr. Gray?
Yes, ma'am,
Where do you work?
for myself.
What do you do?
Take the federal labor law posters.
Say it again.
Labor law posters.
Okay. So what I need you to do, Mr. Gray, if working for yourself isn't going to make it where you can afford an attorney, then you need to try to get an additional job. Because it's important that you're able to try to hire your own attorney. You're able-bodied, there's no issues from what I can tell. So what's that?
Pancreatic cancer.
Are you on Social Security disability? Okay. Are you currently in treatment?
Well, we found out in November. I think it's November. I think it's got me on meds for right now. I think that's it. 4 of them. I gotta go back to Methodist and I owe that bill too. So.
What?
I owe that bill also for the hospital. Blue Cross and Blue Shield only pays for a certain amount.
Where are you going to the doctor in the hospital for that?
Methodist over in Conroe.
Okay. So what I'm going to do, Mr. Gray, is reset your case for a normal reset. I want you to bring a couple of things. One, I want you to attempt to try to get a job if you can, or try to hire somebody still, talk to some others. But also if you have, I want documentation of any current medical issue, appointments, diagnosis, things like that, and we'll see what your options are. Make sure you bring all of that. Step in front of the clerk. She'll give you your reset notice.
Thank you. I do apologize.
Yes, sir. Yes, sir. Thank you.
Thank you.
Mr. Garrett.
I apologize as well, being late.
It's very important, Mr. Garrett. Same thing. If you're not here on time, then you end up with a bond forfeiture and going back to jail. So make sure you try to be here on time. And Mr. Garrett, were you able to get a lawyer hired?
Not yet. Brittany Holmes is appointed to me, but
Did you talk to some lawyers like I asked you to?
I hadn't had a chance to. I gotta go. I regular job as well.
Right, but when you were here last time, I told you to talk to at least 3 lawyers and bring me those names, right? And you didn't do that. You just made that decision.
I spoke to
Well, you're going to be honest about what?
that I hadn't restarted anyway.
So, I mean, but it's so frustrating to me because I told you the same thing I tell everybody. What can happen if you don't do what I told you to do? I mean, it's not, I'm sorry. I mean, you don't want to go to jail, right? And so all you have to do is follow some simple instructions, talk to 3 lawyers, and you stay out of jail. Don't do that. And it's like you're just looking at me saying, I don't have to do what you do. Doesn't matter if you're the judge, and I'm sorry, and we get away with it. So I'm going to reset your case 2 weeks. You either need to get a lawyer hired or you need to talk to 3 lawyers within 2 weeks, which means you better get started this week. If you have not talked, that doesn't mean just calling and leaving messages. That means talking to about your case, getting their fees, and bringing me that information back if you have not hired someone. If you don't do that in 2 weeks, your bond will be raised for not following that court order. There's no I'm sorry at that point. You understand? Step in front of the clerk. She'll give you that reset.
Asterisk, this hearing proves that justice isn't always about choosing between mercy and punishment, it's about following the law, even when emotions run high. The judge had to balance the victim's losses, the defendant's criminal history, and the legal limits of the case before making a decision. Whether you agree with the outcome or not, one thing is clear, every detail mattered, and every decision carried real consequences. Now it's your turn. Do you think the court made the right call by focusing on probation and limited restitution, or should jail time have been the answer? Let us know your thoughts in the comments below. If you enjoy real courtroom breakdowns with legal insights and dramatic analysis, don't forget to like, subscribe, and turn on notifications so you never miss the next case.